Understanding Article 342 of the Indian Constitution, the constitutional provision that defines who scheduled tribes are and how they're officially recognized. In this episode of Consumer Times, we break down the amendment process, the role of state governments and the president, and why this article is crucial for tribal welfare and rights in India. Namaskar, welcome back to Consumer Times, where we decode the laws that shape your rights and your life. Today we are exploring a crucial constitutional provision that affects millions of Indians, Article 342, which deals with the recognition and specification of scheduled tribes in our country. Before we dive deep into subject, please give your valuable comment, share this video to benefit others and subscribe this video to motivate us. Article 342 is often overshadowed by discussions about reservations and welfare schemes, but it's actually the foundational article that determines who qualifies as a scheduled tribe in India. Without this article, the entire framework of tribal rights, protections, and benefits would lack constitutional legitimacy. So let's understand what makes this article so important and how it actually works. At its core, Article 342 establishes the constitutional mechanism for identifying and notifying scheduled tribes. The article states that the President of India may, with respect to any state or union territory, specify the tribes or tribal communities which shall be deemed to be scheduled tribes. This might sound straightforward, but there's significant constitutional wisdom embedded in this process. The framers of our constitution recognized that tribal communities vary greatly across different regions of India. What constitutes a tribal community in Jharkhand might be very different from tribal communities in the Northeast or South India. Therefore, the article provides flexibility to recognize tribes on a state-by-state basis rather than imposing a uniform national list. The process of notification under Article 342 involves careful consideration of various factors. Historically, the characteristics used to identify scheduled tribes include primitive traits, distinctive culture, geographical isolation, shyness of contact with the community at large, and social and economic backwardness. These criteria were established to ensure that communities genuinely disadvantaged and marginalized receive constitutional protection. When the President issues a notification specifying certain tribes, that notification must be published in the official gazette. This publication gives it legal force and makes it a public document that can be referenced for implementing various welfare schemes and protective measures. However, here's where it gets particularly interesting from a constitutional law perspective. Article 342 was significantly amended by the Constitution, 102nd Amendment, Act of 2018. Before this amendment, the President could not only include tribes in the list but could also exclude or modify entries through subsequent notifications. This created a situation where changes could be made without extensive parliamentary scrutiny. The 2018 amendment changed this dynamic completely. Now, while the President can still issue the initial notification specifying scheduled tribes for a state, any subsequent modification, inclusion, or exclusion from that list can only be done through an Act of Parliament. This amendment represents a major shift in constitutional practice. By requiring parliamentary approval for changes to the scheduled tribes list, the Constitution now mandates greater democratic oversight and debate. This means that if a state government wants to include a new community in its ST list or remove an existing one, it cannot simply request a presidential notification. Instead, a bill must be introduced in Parliament, debated by elected representatives, and passed by both houses before the President can modify the list. This additional layer of legislative scrutiny ensures that decisions affecting tribal communities receive thorough examination and cannot be made arbitrarily. The practical implications of Article 342 are enormous. Once a community is notified as a scheduled tribe under this article, members of that community become eligible for various constitutional protections and benefits. These include reservation in educational institutions under Article 15, reservation in government jobs under Article 16, special provisions for administration and control of scheduled areas under the 5th Schedule, and various welfare schemes specifically designed for tribal development. The ST certificate that individuals obtain is directly linked to their community being listed under Article 342 for their specific state. It's also crucial to understand that scheduled tribe status is state-specific. A community recognized as ST in one state may not automatically have the same status in another state. For example, certain communities might be notified as scheduled tribes in Madhya Pradesh but not in neighboring Uttar Pradesh. This state-specific nature reflects the regional diversity of India's tribal populations and acknowledges that the socio-economic conditions of the same community can vary significantly across different geographical areas. The role of state governments in this process is consultative but important. Before the President issues a notification, the concerned state government is typically consulted because state authorities have better ground-level knowledge about tribal communities residing within their jurisdiction. State governments often initiate requests for including new communities or subgroups in the ST list, but after the 102nd Amendment, these requests must go through the parliamentary route for approval. From a consumer rights perspective, understanding Article 342 is important because it affects how government schemes and benefits are designed and delivered. Many welfare programs, subsidies, and protective measures are specifically targeted at scheduled tribes. Companies and service providers often have to maintain ST quotas in employment and education. Banks offer special loan schemes for ST entrepreneurs. Knowledge of Article 342 helps tribal community members understand the constitutional basis of their rights and ensures they can demand proper implementation of benefits. Critics have sometimes questioned the criteria for tribal identification, arguing that they may be outdated or that the process of inclusion is too slow. Many communities have been waiting for decades to be included in the ST list. The parliamentary requirement introduced by the 102nd Amendment, while ensuring democratic accountability, has also been criticized for potentially making the process even more time-consuming. However, supporters argue that this parliamentary scrutiny prevents arbitrary decisions and ensures that tribal status is granted only after thorough examination. In conclusion, Article 342 is more than just an administrative provision. It's a constitutional commitment to recognizing and protecting India's tribal communities by establishing a clear, democratic process for their identification. This article works in tandem with numerous other constitutional provisions to create a comprehensive framework for tribal welfare. As responsible citizens and consumers, understanding these constitutional provisions helps us appreciate the legal foundations of social justice in India and ensures that those entitled to benefits can actually access them. Thank you for watching Consumer Times. If you found this explanation helpful, please like, share, and subscribe for more content on constitutional rights and consumer awareness. Leave your questions in the comments below, and we'll address them in future videos.